Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. Minimum wage increases take effect today, July 1st, for employees in Alaska and Oregon. Healthcare and hospitality workers in California and California employees in several cities will also see minimum wage hikes beginning today. Employers may soon have the option to increase employee access to fertility treatments, as several agencies have proposed expanding federal benefits. The Departments of Labor and Treasury, together with the Department of Health and Human Services, have issued a proposed rule to allow employers to provide fertility coverage as a limited accepted benefit exempt from Affordable Care Act and HIPAA portability requirements. The benefit would cover diagnosis, mitigation, or treatment of infertility or infertility-related reproductive health conditions by a licensed or authorized medical professional. Under the proposed rule, employees would be able to opt for this coverage without enrolling in a group health plan. Comments on the proposed rule are open till July 13th. Medical marijuana doesn't pass the test. The Justice Department's reclassification of medical marijuana as a Schedule III drug earlier this year raised questions for many employers. The U.S. Department of Transportation has an answer for DOT-regulated employers. A positive drug test for marijuana is disqualifying, even if the employee has a state medical marijuana license. The guidance asserts that a rescheduling decision under the Controlled Substances Act does not amend the regulation that governs testing. So under federal law, a state medical marijuana card is not a valid medical explanation for a positive test. Whistleblowers in Massachusetts are protected, even if they're complicit in a violation. That's according to the state Supreme Judicial Court. In this case, a community college failed to report allegations of sexual assault lodged by a student as required by the Federal Clery Act. The plaintiff, who was in charge of campus security, initially failed to submit required reporting, but ultimately blew the whistle on his employer for encouraging the omission. The court ruled that the plaintiff's subsequent termination could be deemed to violate the Massachusetts Whistleblower Act, regardless of the plaintiff's involvement in the violation. That's it for this week. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.